today class, for today's topic, it is all about the role of evidence. What exactly is the role of evidence and how important is it? First, let us define what is evidence. According to Collison's English Dictionary, the evidence is the information which is used in a court of law to try to prove something. It can be obtained from documents, objects, and witnesses. It is a proof of allegations. Anything that can be used to prove something. So, it means that it is information that can be used to a court to prove something in allegation. There are three classifications of evidence. This is the direct evidence, indirect evidence, and hearsay evidence. First is the direct evidence. This is a kind of evidence according to the five senses of the witness. It is witness testifies based on what he saw, heard, smelled, touched, or tasted. That is the direct evidence. Next is the indirect evidence. The indirect evidence is also called a circumstantial evidence that seeks to establish a conclusion by inferences from the facts proven. The indirect evidence, example of it is a fingerprint, semen, bloodstain, and etc. that may lead for the liability of a suspect. Next is the hearsay evidence. A hearsay evidence is a statement made by a witness on the authority of another and not from his own knowledge or observation. The example of hearsay evidence is a dying declaration. Now, let's go to the topic of scientific evidence. What is scientific evidence first? Scientific evidence also means an information gathered from scientific research which takes a lot of time to conduct. It means the scientific evidence has a process. Now, there are three forms of scientific evidence. This is the real or autoptic evidence, testimonial evidence, and documentary evidence. A real or autoptic evidence is a physical evidence that can be seen and inspected through the jury's own eyes. These evidences have probative value but do not play a direct role to prove or clarify the subject matter in questions. Example of it are weapons that was found and used in a crime, like knife, gun, and etc. Next form is the testimonial evidence. A testimonial evidence, it is a verbal information provided by a witness in a court of testimonies. It is a sworn statement of witnesses made in an open court. It is broad sense. This type of evidence includes oral and written statements made by witness under oath and a statement procured by the police from witness, victims, or suspects during interrogations. And the last forms of scientific evidence is the documentary. Documentary evidence is introduced at a trial in the form of documents. Documents as evidence consist of writing or any material containing letters, words, numericals, figures, symbols, or other modes of written expressions offered as a proof of their documents. The example of it is a newspaper, official documents, certified copies of public records, certificates of custodian of business record, and etc. Now, let's go to the witnesses. There are several types of witnesses. There was a lay witness, expert witness, character witness, eyewitness, material witness, and ordinary witness. Let's define every one of it. The first is the lay witness. A lay witness testifies about first-hand knowledge based on what they heard, saw, or did. A lay witness can only use based their opinion or information they personally observed. Expert witness. Next is the expert witness. Expert witness is a person with specialized skills set whose opinion may help a jurist make sense of the factual evidence of a case. The expert witness must be qualified through training, specific knowledge, and experience. Example of expert witness is a medical legal officer, pathologist, doctor, biostatisticians, and etc. Next is the character witnesses. Character witnesses is a person who gives evidence in a legal action concerning the reputation, conduct, and moral nature of a party. Someone who knows the victim, the defendant, or other people involved in the case. Next is the eyewitness. An eyewitness is a person who actually sees some act, occurrence, or thing and can give a first-hand account of it. Next is the material witness. A material witness is also called a whistleblower because it is a witness who possesses information going to some fact that affects the merit of the case. It can be a person who is considered to possess great information powerful enough to determine the outcome of the case. So the court will make every effort to receive the testimony and delay the trial if necessary. So that's it. Then the last is an ordinary witness. An ordinary witness is someone who personally saw or heard something about the crime. An ordinary witness can be the police officer who made the arrest of a person or who was at the scene of the crime. That's it, last. So thank you for listening and God bless you all. Thank you.